Please be seated. Thank you so very much. The Honorable the Chief Justice, Your Excellency, Ambassador of the European Union to Rwanda, the Honorable the Deputy Chief Justice, distinguished heads of institutions, and members of the justice chain present here, justices, judges, and judicial officers of the superior and subordinate courts, members and partners from the civil society, distinguished members from the academia, members of the Multi-Institutional Committee, MIC, dear guests, ladies and gentlemen, a very good morning. To those that don't know me, my name is Justice Harrison Mutabazi. I'm a judge of the High Court. I currently work with the Inspectorate Department, but also the spokesperson of the Judiciary of Rwanda. And I'm so delighted to be your MC in this a very long overdue time that we waited for this event to come in, and we are so grateful that it has happened. To those that don't know, we had this in mind for almost 4 years, and we had this thought hatched around that time. So having it today happening, we are so thrilled today. My task is to members of the institutions in the justice chain who are also in attendance. We have the Honorable, the Prosecutor General, the Honorable, the Secretary General of Rwanda Investigation Bureau. We have the President of the Rwanda Bar Association. We have the Chairperson of the Rwanda Law Reform Commission. We have the Permanent Secretary of the Ministry of Justice. We have Commissioner Tutsi representing the Honorable Inspector General of Police. We have also Mr. Karambizi representing the Minister of National Unity and Civic Engagement. We also have members of the civil society that are also in attendance. We have the ED Legal Aid Forum also in attendance. We have the Executive Secretary Haguruka also in attendance. We also have members from the academia that have ably attended this function. We have the Rector of ILPD. We have the Deans of the faculties of UR, ULCA, University of Kigali, and INLAC also in attendance. And we also have members of the Multi-Institutional Committee that have done a lot this that we're celebrating today that are all in attendance. And of course, the press that is also in attendance. So please give me a round of applause to everybody that is in here. All right. Thank you so very much, and thank you once again for honoring our invitation and coming in good numbers, and especially our online community that is following us there. We hope definitely that you'll be enjoying our event as it goes on. Today the agenda is going to be running as follows. Of course, to launch this special law report on genocide against the Tutsi cases, and definitely to know what is MIC. People have been asking us, what is MIC? What do they do? We will be definitely having a segue from the president of the Multi-Institutional Committee, who will be taking us through what law report is, how it's compiled, and everything, and nitty-gritties. And after that, we will have a panel, an able panel, that will be moderated by Justice Isabel Hangabo, to take us through on the all the members that definitely contribute to the report that we are celebrating today, that we're launching today, and they'll be telling us what they do on a daily basis. And after that, we will have a speech from Her Excellency, the Ambassador, and then we will be transitioning to the end. We will have remarks from the Honorable or the Chief Justice, who is also the guest of honor, and who will definitely do the launch. And then we'll be transitioning to the end, where we'll have a group photo, and all of us are invited for lunch. And I want to let you know that all the guests that are here, you'll be having a copy, a physical copy that will be handed over. You've seen our stands that are outside, you have a copy. And then the rest, the hosts, you can have them, you'll have them virtually. Without further ado, this honor, I want to invite Justice Professor Ngaji Alphonse. He told me I just introduced him as the Justice of the Court of Appeal, because if I would take time to read his CV, it will take the entirety of this session. So he has very much humbly accepted to be invited as a justice of this. Give him a round of applause as he comes. Thank you so very much, Justice. All right.
Honorable Chief Justice of Rwanda, Your Excellency, Ambassador, European Union Ambassador in Rwanda, Honorable Deputy Chief Justice, representative for government institution, academia, development partners, and all stakeholders present today, distinguished guests, good morning. I have the pleasure to make a presentation before your audience on law reporting and MIC. I do not expect my English be good like Justice Mutabazi, due to my background, but I will try to do my best. Don't mind the quality of my English. The law reporting, I'm going to explain the law reporting in general and the special law reporting and what is MIC, its organization and how it works. The law reporting, the practice of tracking and monitoring how law develops through the analysis and publication of landmark court decision known as precedents. A precedent is a judgment or decision of a court, typically recorded in a law report, used as authority for similar subsequent cases. In Rwanda, we operate under an hybrid legal system which integrates best practices from various global legal traditions for efficiency. This approach has led to the incorporation of the doctrine of precedents, a fundamental principles derived from the common law system. Here we have two main legal maxims. The first one is stare decisis et not quieta movere, which means to stand by and adhere to a decision and not disturb what is settled. This maxim dictates that cases with similar circumstances should be decided using similar legal principles, ensuring consistency and predictability in legal outcomes. It means it is the stability of decisions. The second one is res judicata pro veritat ebatur, which means an adjudicated thing is regarded as the truth. This principle means that a matter already decided by binding judgment will be upheld and not litigated by the same or different tribunal, promoting finality in judicial proceedings. What is the importance of law reporting? The main importance is to ensure court decisions are accessible to all legal stakeholders like judges, prosecutors, lawyers, researchers, and the general public. This accessibility offers several critical advantages, which are consistency and certainty, efficiency, for judges, justice and fairness, upholding judicial ethics, enforcing uniform standards, and facilitating legal practice. These are some advantages of the legal precedent. But what is the scope of legal reporting? The legal reporting encompasses a broad spectrum of judicial pronouncement, including ordinary judicial decisions, landmark cases, constitutional interpretations, and thematic issues of public interest. The scope ranges across a diverse legal domain, from civil and commercial matters to commercial disputes, administrative law, and human rights cases. This was our report in general, but for part 2, we're focusing to law Rwandan reports. Regarding the background, we start with la revue juridique, which started in 2004 until 2010. After that, we had the Council of Legal Reporting, which was established in 2010, and this council published in the first law report, its first law report, volume 4, in January 2010. Over the next 4 years, it diligently released more than 20 volumes, greatly enriching Rwanda's legal literature until 2014. We have also, in 2014, the MIC, which is Multi-Institutional Committee, was created. This year saw the recruitment of permanent law reporters, dedicated professionals focused solely on the systematic documentation of legal decisions. Concurrently, the Council for the Law Reporting underwent another significant restructuring. The expanded Council now included new members from various institutions within the justice sector, along with representation from all schools of law in Rwanda. The broader composition aimed to foster comprehensive legal scholarship and academic research, integrating diverse perspectives into the law reporting process. Under the MIC guidance, the law reports began to be published in 2 official languages, Kinyarwanda and English, significantly increasing accessibility. The first volume published under the MIC's purview was released in July 2014. This was the volume number 1, marking a new area of inclusive and robust legal documentation. And in 2021, we had a legal instrument, which was the Chief Justice Instruction on March 21st, and this instruction specially relates to the publication of law reporters, ensuring clarity, consistency, and adherence to best practices in Rwanda legal documentation. This dictates that good law reports must necessarily include new principles and rules. It means that all cases which introduce or appear to introduce a new principle or a new rule. Resolving doubtful law, it means that all cases which settle or materially tend to settle a question upon which the law is doubtful. We have also modified the principles and the rules. It means that all cases which materially modify an existing principle or rule, and instructive cases, which mean that all cases which for any reason are peculiarly instructive. These are the criteria which dictate a good law report. And for the organization of Rwanda Law Reports Committee, or MIC, the MIC is composed of the following: judges representing the Supreme Court, Court of Appeal, High Court, High Commercial Court, Intermediate Courts, Commercial Court, Primary Courts, and the representative of the Inspectorate of Court. All are nominated by the Chief Justice. We have also representative of military courts, prosecution, bar association, schools of law, ILPD, Minigist, Rwanda Law Reform Commission, and law reporters. Those are the members which compose the MIC, or this committee in charge of law reports. The committee is divided into 4 specialized subgroups that review cases before presenting them for final approval to the plenary session. We have the first group is administrative, labor, and specialized cases like genocide and constitutional matters, commercial cases, criminal cases, and civil cases. Each group has the chairperson and secretary, and it examines cases for publication criteria, ensure a proper drafting, and submit them to the plenary session. This is the organization of MIC, but what about the functioning of MIC? The selection of cases to be included in the Rwanda Law Report follows a rigorous process managed by the MIC, which is equivalent to the Council of Law Reporting in other jurisdictions. The committee ensures that cases selected are of a presidential value, address important points of law, and contribute to the development of Rwandan jurisprudence. These are the main points for the selection of cases to be published in Rwandan Law Report. The preparation of cases for publication is undertaken by law reporting team, ANAMO, say ANAMO, and approved by General Inspectorate of Courts before being submitted to the MIC. It means that we have 3 steps. We have law reporting team, we have General Inspectorate of Courts, and the MIC, which is the last instance for approval of cases to be published in Rwandan Law Report. During the plenary, because we have a plenary session, each group presents the cases it has approved, because we have the 4 groups. Each group work on the cases, and following this field of specialization. And each group presents the cases it has approved, explains the reason for approval, and identify those rejected and the reason for rejection. We cannot select all cases. It means that we try to follow the criteria as cited above. The cases are then debated in plenary. Generally, it is in the afternoon from 2 p.m. up to 6 p.m. The cases are then debated in the plenary, and only those that meet the highest standards are finally confirmed for publication. This is the process of selection and publication of cases in law reform report. It is important to emphasize that only cases decided at the final instance are published in Rwanda law reports to ensure the authority and finality of the jurisprudence disseminated. This was the procedure for selection of the case to be published in the law report, the Rwandan law report. But what are the products of Rwanda law report? We have ordinary law reports, which cover a wide range of cases decided by Rwandan courts. They are the backbone of Rwandan law reporting system, ensuring that routine yet significant decisions are accessible and systematically reported. And we have a special law report like this. They contain cases in a defined area of the law or a particular legal domain. These include a special law report on constitutional matters and the one, like the one we are launching today, which contain the case on genocide against Tutsi in 1994. And we will continue with other areas that need more emphasis. By concentrating our specialized areas, these reports offers deeper insights and provide tailored guidance for practitioners and policymakers. We have also a new product, which is a Law Digest. A Law Digest, instead of full court opinions, a digest provides the key legal point, facts, and the ruling of individual cases in a condensed format. Currently, Rwanda Law Report published the Insurance Law Digest, which contains Supreme Court landmark cases and judicial interpretation of the insurance law. This digest serves as a practical guide for lawyers, insurer, regulator, and consumer, providing clarity on how insurance principles are applied in our courts. For the dissemination of all reports, dissemination of all reports involves sharing court judgment and legal decision with the public, legal professionals, institutions, and other stakeholders through various channels, like we have physical dissemination. It involves distributing them in a non-digital format, such a bound volume through libraries, law firm for legal professionals and the public. This method allows direct access to physical copies and ensures a permanent record of precedent. We have also online law reporting. We have digital accessibility. Here, online law reporting provides digital access to case law in partnership with the Ministry of Justice and the Rwanda Law Reform Commission. The judiciary offers online law reporting database at www.amategeko.gov.rw, making all law reports readily accessible. We have also a comprehensive content and search. This platform published judicial decision, including the full text of judgment, catchwords and summaries of fact and holdings. This comprehensive indexing enable users to conduct exhaustive and advanced researches on the judiciary, most significant judicial rules, and we have also widespread dissemination. Beyond traditional court libraries, online law reporting has played a pivotal role in the efficient dissemination of these crucial law reports to all stakeholders, ensuring broader access to justice and legal information. As the challenges, we have limited resources. Both human and financial constraints have sometimes impacted on the pace of publication and the number of copies produced. We have also growing cases complexity. Here, the increasing complexity of cases demands specialized expertise and lead to time constraints. But we think that these challenges will motivate us to innovate, collaborate, and strengthen our institutional capacity. In conclusion, the launch of the special law report represents not only the consolidation of our achievement in law reporting, but also the beginning of a new chapter. It is a call to action for all stakeholders to support this initiative by contributing expertise, ensuring sustainability, and promoting the use of this report in legal practice, teaching, and policy making. As the recommendations for the digital accessibility, continue investigating technology and digital platform to make law reports more accessible to all users, standardization and benchmarking, implement standardization and benchmarking to align Rwanda law report with international best practices. Capacity building, strengthen the capabilities of institutions and professionals involved in the law reporting process. And lastly, enhance collaboration to encourage greater collaboration between the judiciary, academia, and the bar association to ensure reports remain relevant and authoritative. Distinguished Honorable Chief Justice, Your Excellency, European Union Ambassador, distinguished guests, with these few remarks, I thank you once again for joining us in celebrating this milestone. Let us embrace law reporting not just as a technical exercise, but a pillar of justice, transparency, and the rule of law in Rwanda. Thank you.
Thank you once again, my Lord Justice Prof. Ngaji, for taking us through the nitty-gritty of law reporting and MEEC and everything. And I'm very contented that definitely every one of us that is here and those that are following us online, that you've learned one or two things from the presentation that is done, of course, the professor in his making. We are transitioning to another segment. As I said, we'll have a panel discussion that is going to take us through briefly on what the actors that are on this panel all are contributors to this special law report of genocide. And definitely we're going to learn a lot from them. And to take us through this panel is going to be ably moderated by her ladyship, Justice Isabel Kalehangabo. Please welcome her as she comes on the stage with a thunderous clap. Please clap as she comes up. Thank you very much. She also requested that we don't take a lot of time introducing or making her bios, reading her bios. We will just let you know that she's a justice of the Supreme Court, and she will proceed with introducing the rest of the panelists and take it up from there. Thank you so much, my lady. You have the floor. Thank you so much.
Thank you, Harrison. Honorable Chief Justice, Excellency Ambassador of the EU, distinguished guests, all protocols observed. Good morning. I'm honored to chair this panel, which is going to discuss about the law reporting and the special law reporting, especially on the cases of genocide against the Tutsi. And following the panel members, I'm going to invite and ask them to come forward. I would like to invite Dr. Aime Muyoboke Karimonda, Rector of the ILPD, Maitre Ngundabarashi Moise, President of the Bar Association, National Prosecutor Jean Bosco Siboyintore, Head of the GFTU, and Justice Didas Nshimiyimana, Judge of the High Court Chamber of the Specialized Chamber of the International Cases. As the MC has mentioned, all these distinguished people are contributors to the law reporting, but they're also specialists in the area, not only of law, but also in different fields. I have mentioned their names, and I'm going to follow the already established precedents by the MC Harrison. I'm not going to make a full presentation of all of them. They are all part of the justice sector, and all of us here were from the justice sector. But for the sake of our guests who probably don't know much on them, I would want to mention that Dr. Aime Muyoboke, right on my left side, has been also a judge to the Supreme Court and is now director of the ILPD. He's also been the president of the Court of Appeal. Then we have next Maitre Ngundabarashi Moise, the president of the Bar Association. That is already enough as a personality on the Bar Association. Then comes Jean Bosco Siboyintore. He's the head of the GFTU, Genocide Fugitive Tracking Unity in the National Prosecution. He's been there for a long time, and he has a number of information about genocide fugitives, the tracking, and has been following cases of the genocide which have been tried in courts. And he's been also following the trial of genocide suspects across the world. He has been following all those cases that has been adjudicated by in other countries. We have also Justice Didas Nshimiyimana, actually Dr. Justice Didas Nshimiyimana. He's a judge in the International Criminal Chamber of the High Court of Rwanda. He's been also a judge handling some of these cases. You understand that they have a lot to tell us, and with no further ado, I would like to invite Justice Didas to tell us about a little bit more about this report we are launching today. As a judge of the chamber, some of your judgments are in this report. So can you briefly tell us about this special report and probably let us know which are the major cases in this report those people should know, and if you have time, and I hope so, tell us about the major rules that the judges have established within those cases.
Okay.
Dr. Didas.
Thank you, Chair. Honorable Chief Justice, distinguished guests, as said by the Chair, I'm going to talk about background of this special report, specifically on the structure and the content-wise. And then I will talk about some rules or cases to be remembered. This special report, entitled The Case on Genocide Against Tutsi, it comprises cases on genocide perpetrated against Tutsi in 1994, tried by High Court Chamber specialized in hearing international and transnational crimes, cases of the Court of Appeal and Supreme Court. It contains 20 criminal cases in merit, and those cases involves 20 accused. Some of them was transferred in Rwanda by the state, and others by International Criminal Tribunal for Rwanda, and other apprehended in Rwandan territory. 7 cases has been rendered by the High Court, 10 cases by the Court of Appeal, and 3 cases by the Supreme Court. The introductory pages includes elements in introduction, list of all reported cases with the names of accused, and the subject index. This subject index will help readers, practitioners, researchers quickly find specific information and the legal concept as it lists the key terms alphabetically and indicate the pages where the court discussed the specific legal issues. For content-wise, the present special law report, for each case, the law report provides head notes and full text of the judgment. The head note includes keywords and the main rules of essential points of law stated in the decision, a brief summary containing the facts, the holding of the courts, as well as the statute of laws, cases, books, and academic articles referred by the court in legal analysis. The full text of the judgment details the full names of accused, factual background, issues to be analyzed, the submission of each party, statement of witness, if any, and the court reasoning and decision of the court. For the key legal concepts that are in this special law report, this special law report deals with issues arising from the law determining offenses and penalties in general, specifically articles related to the crime of genocide and international crimes, international conventions, international customary law, the Criminal Procedure and the Evidence Act. For that, the report covers matters such as crime of genocide and explain more what is special intent that is needed in the case of genocide, criminal liability in the case of genocide, administration of evidence, alibi defense, validity of testimonies and other pieces of evidence, and sentencing. In gross, considering the decision of the court, some of the accused have been convicted of genocide, as Twagiramungu, Yamuremi and others, complicity in genocide, as Uinhindi, complicity by omission, public incitement to commit genocide, as Mugesera, conspiracy to commit genocide, Habyarimana, and others were not convicted of committing the crime of genocide, as Dr. Munyakazi. Honorable Chief Justice, let me talk about the major rules briefly in case to be remembered. In this special law report, the courts that the High Court, the Court of Appeal, and the Supreme Court explain a lot on different keywords and the legal points that is needed in adjudicating criminal cases. But they explain on the validity of testimonies in the case of prosecution Wingindi. The court stated that the fact the witnesses are diverging or inconsistent due to the time elapsed does not discredit the credibility and the quality of their testimonies. In Twagirayezu, the Court of Appeal explained a lot, even the details, and stated that the witness's contradiction about the hours, days, date, clothes of accused is not ground to undermine them and discredit their testimonies. I think this legal reasoning of this court will not help only in the cases of genocide, if it can be used by other courts when assessing testimonies in different cases. Secondly, the alibi defense or defense alibi is found in case Tamabyariro, Vilindabagabo, and Kwagirayezu, or the case of Court of Appeal. The court stated that when accused pleads an alibi or was not at the scene of crime, the prosecution must provide evidence to prove the crime in general, particularly by continually provide evidence that prove beyond a reasonable doubt that the accused was at the scene of the crime. However, suspect who claimed that he was not at the scene of crime at a certain time and therefore could not have committed the alleged crime remains solely responsible to provide or for providing that he was not at the scene of crime. This defense of alibi can also be used in different defenses in criminal matters. Thirdly, joint criminal enterprise. The joint criminal enterprise has been explained in the case prosecution Twagira Mungu, tried by the High Court Chamber specialized in hearing international and transnational crimes. Normally, Rwandan law provides the mode of criminal liability as offender, co-offender, and accomplice, even command responsibility. This court extends the mode of criminal liability and institute the joint criminal enterprise. The joint criminal enterprise refers to the mode of liability used in ICTR and ICTY that extends criminal liability to willing members of criminal groups or members of case of deadly attacks. It allows court to try defendants who knowingly and voluntarily participate in a criminal group in attacks as co-perpetrators at the crime, even if there is no evidence that the defendants physically committed the crime themselves. After analyzing this case, the court explained that the basic form of joint criminal enterprise, taking in mind that this joint criminal enterprise have three forms: basic, extended, and systemic. The court considered the basic form of joint criminal enterprise and stated that it is an agreement between many persons to engage in the commission of an offense by implementing the criminal intent in such a way that each of them is considered a co-offender, even though the act of slaves has been performed by only some of them. There is also liability of authorities. You can find this liability of authorities, commanders, superior liability in case of Supreme Court of Abyara Batuma. The court stated that the liability arises where an authority knew or should have known that persons under its authority were about to commit an offense and did not prevent them from doing so, or even take punitive action against them. I highlighted the second point that liability, this liability applies even if the authorities concerned were recruited illegally. Okay, let me thank Chief Justice for my presentation. I give floor to...
Thank you, Didas, for taking us through the special report and mentioning some of the key case precedents that have been established in those cases. Let's see how now the users are perceiving this report. And Director, I would like to ask Jean Bosco Siboyintore, this report, as being on cases of the genocide against the Tutsi, it contains some cases of suspects which were apprehended at the international level. And you've been key in apprehending those suspects. So how do you think this report is going to help the prosecution in the tracking and prosecution of the genocide suspects, especially fugitives one?
Thank you so much, Madam Moderator, and Your Lordship, Chief Justice, Excellency, the European Ambassador to Rwanda, all protocols observed. Allow me, first of all, to thank the judiciary that have invited us, NPPA, to come here, especially and be given a platform to express our views on this special law report that is going to be launched. First of all, I think we are one of the beneficiaries of this report. When I saw the report and was going through, I found that I could not be, I was very happy to the extent that I thought that we now have a special report that addresses the issues which we, before they came into existence, we were finding in other case laws to address our own cases. NPPA pursued high-profile genocide cases which appear in the special reports, such as the Bandora Charles case, which we brought from Norway, the Mugesera case, which we brought from Canada, Mujimba and Yamuremi from the Netherlands. Then we have Twagirayezu Weseserans from the Denmark, Munyakazi from the United States, and Bindabaga from Jean-Paul from Uganda. And then we have 3 cases that we pursued and brought from the through Rule 11B's referral cases from the ICTR, the cases such as the Zhao Winhind, which is the first case that was referred to Rwanda after a long fight, because the ICTR had not located cases in Rwanda before 2011, because we tried in 2008 in the cases of Mnyakazi and Gaspar, is it Hajabachiga? Then we could not pursue. We could not, and Mnyakazi, in those rulings, they said we were not yet ready. So what it meant, that the judiciary was not yet ready, and we had to do a lot of exercise here and there. We worked on those areas which were demanding, of course, working on laws, witness protection issues, of course, some facilities such as detention. And we went back in 2010, and I remember among the people that went to the ICTR to pursue again for these cases, I was with the Deputy Chief Justice here present, Honorable Hitiarem, and we convinced them that we are now ready. We convinced them, and that's how the Winhind case came in 2011, after conviction that indeed we had everything that needed to refer some cases to Rwanda. And from that period, other countries, foreign countries, started referring cases here to Rwanda based on that jurisprudence, that case law. I just want to build to show you how the cases here now in the special law reform report is so important which we will be relying on, trying to pursue other countries to refer cases to Rwanda. Now we will be also looking at our own jurisprudence or case laws to refer, as Justice Didas has already explained how important they have been and which areas they have addressed, whether it is an alibi or a ribi in Virindabagabo, we know, and whether it is the issue, the component of complicity, how complicity is dealt with in a rather Mujesera case. So we have now a pool of judicial cases to refer to while we are drawing our own indictments to other fugitives we will be pursuing. We also had another golden chance, I may call, in the case of Sweden versus Ahorogeze, that is the European Court of Human Rights decision, which also solidified the importance of referring cases to Rwanda in extradition, indicating that Rwanda's judiciary was independent and could adjudicate cases with fairness. Indeed, the case of Zhao Winhind, which was a landmark judgment, followed other decisions and these could be the Bernard Munyagishar, Ntaganzwa Radislas, which are also mentioned in the special report. But we also had other fugitives who were sent here through the ICTR Rule 11bis, which we can be happy with. So how are we going to benefit from this? Of course, we will be using our own legal precedent to also show that we can convince foreign countries that the cases you referred to Rwanda, by the way, it is even one way also of informing, reporting back to these foreign countries that trusted us with the extraditions, that we would adjudicate with fairness, that we have done so. There is one thing, when we were pursuing these cases, there is one negative school of thought we did not buy when we were asking these foreign countries to bring these cases to Rwanda, so that they can be tried here. There was this negative school of thought which equated the sentencing in Rwanda as 1 + 1, which is 2, meaning that whenever a case is sent, genocide case is sent to Rwanda, it will always amount to death penalty, rather to life imprisonment sentence, which was not the case. We proved to them it is not the case. We referred to some cases which had been adjudicated during Gacaca cases, of course during the Gacaca judgments, but they could not be, they were contested that those are Gacaca, and Gacaca are nothing almost. So in courts. But now we have a special law report with the cases which has been referred by the international tribunals, and also which have been referred by states, the countries which I mentioned, and we will be saying, no. When I was reading, I found also in these cases that there are even a person we extradited, we brought from United States, whom the courts of Rwanda acquitted because of insufficient evidence, and that is other than the case of Dr. Munyakazi. And the negative theory I was saying, the school of thought that I was saying that, which said that whichever case, as long as it is genocide, whichever case you refer to Rwanda, it is going to be life imprisonment sentence. No, the special, when you read these judgments, you will find these judgments that there is, if you say Yamureme and Mujimba, they were convicted to a term of 20 years imprisonment, 23, 25. You will find that what they were telling, or what they were saying, the so-called experts were saying in those foreign jurisdictions to deny us extraditions, that whatever they sent, the case sent to Rwanda, is they don't, our judges don't go, don't motivate, don't. So this is a testimony, it is a statement that we are going to build on and convince other genocide fugitives to be referred to Rwanda, because the special, we will be also referring to the special report with all these cases, and we will be like, it will be also like a guide to guide them to read further into those specific judgments that have been identified. In my conclusion, I cannot conclude without saying that even when these people are brought to Rwanda for trial, the prosecutors will prepare indictments. We prepare indictments which we send to the court, and we must prove our cases. The criminal liability is proven by prosecution, and we need to state carefully the modes of liability of each, and it has been highlighted in this special law report. So it is also a benchmark that prosecutors will always refer to whenever they want to make indictments or argue cases before the courts in Rwanda, whether it is the High Court, the Court of Appeal, and even where it necessitates even at the Supreme Court. So it is, I will conclude just saying that I saw the happiness of the Christians when they got a new Pope, Leo Pope the 14th, how they were happy. So you can imagine how a prosecutor can be happy when he sees such a report which will help him to argue cases in court. I thank you.
Thank you very much, Happy PN Bosco, for sharing your happiness about this report and how it's going to help you in your day-to-day job. I can mention what you said. You said that this is going to help you prepare your indictments using our own cases. And it is going to serve as reporting back to those countries who trusted in our system and sent genocide suspects to be tried here in Rwanda. And that thing also to note is that it is going to, it is dismissing some negative thoughts that about the Rwanda sentencing. And as you say, we believe that it's going to be a key tool in now having more suspects transferred to Rwanda and sent to Rwanda to be tried while they committed the genocide against the Tutsi. Thank you very much. Now I would like to ask the President of Bar Association, Maitre Moise. The Bar Association is one of the beneficiaries of these reports. How user-friendly do you find these law reports? Not only this one specialized, but all the law reports that lawyers are supposed to be using in preparing the pleadings before the courts. How easily accessible do you find them? How is it being used by lawyers?
All right, thank you very much. Honorable Chief Justice, Excellency Ambassador of the European Union, distinguished guests, good morning. I don't know whether it's still in the morning. So, first of all, I want to thank the Chief Justice for the work that is being done in as far as publishing these very cases is concerned, because it's one of those instruments that helps lawyers when they are preparing their pleadings. And this very special law report to do with the cases on the genocide is not only legal instrument, but when I was reading through, I realized that it contains actually quite a good number of aspects of our history. Therefore, publishing it in such a way is very important work that is being done. And I have to say that this is one of the things that that is going to help us also train lawyers in the use of the very instrument. Because one thing that we've realized is, because of our traditions, in as far as the legal tradition is concerned, lawyers, most of them tend to use the laws and ignore the very instrument that were, or even the case law that were published in such a way. But then one thing that we need to be mindful about as the judiciary and all stakeholders, it's the success of this very process of using precedent and jurisprudence relies on certain principles that we need to be mindful about. And one of them is publication, like what we are doing today. But also being mindful about making public and allowing the public to know the cases is what is going to help that we can be successful in the use of this very precedent. I was doing a simple exercise today in the morning before we come to speak to this panel, to look at amategeko.gov.rw, to look at how frequent we update our very website where we are supposed to be finding these very instruments. But when you look at them, you will realize that, for instance, with due respect, the Supreme Court, you will realize that in this year, only 7 cases are published. I'm talking about the top court that is supposed to be giving guidance to the lower courts. And that is 2025. I'm just picking 1 year so that we can look at how we are supposed to be doing it. But there is an improvement that needs to be done. But already the platform shows clearly that there is a lot of work that was done. It's streamlined. You can easily find everything that you want, and it's per court. You see from the Supreme Court to the Commercial High Court, Military Court. And when you look at the International Tribunal for Rwanda, even the cases that were adjudicated in different years, you realize that we really still need to make an improvement in as far as publishing these very cases. Another thing that I wanted to say that is related to the publication again that we commend is the fact that we've considered having soft copies and the printed copies. But I want to believe for purposes of environmental protection, we'll be using the electronic part. And the major part that we thank the judiciary is that now we are doing everything online, and we can easily streamline the access to these very court cases online. Let me conclude by saying that being user-friendly in as far as the publication is concerned, the same way I was putting it, is very crucial. But there is still a lot to do on our side as the Bar Association to train lawyers even to use the precedent, as I said earlier. And we commit that we are going to be doing it. And we believe the necessary collaboration between or among our institutions to make sure that lawyers get access to these court cases is one step, but using them and using them properly is another stage that is of our responsibility as the Bar Association that we need to train the lawyers about. In a few, those are the few remarks that I can make or comments, and I again thank the Honorable Chief Justice for having convened this gathering. Thank you.
Thank you very much, President of the Bar Association. We take note that the website, the new website, amategeko.gov.rw, is there and is already serving its purpose by availing the laws and the case laws. And we take note of the recommendation that it needs to be updated. If we have very few cases of the Supreme Court, that means we still have a way to go. We note that also that these reports help the Bar Association to train the judges, training them by using the case laws and the precedents that have been established available in the reports, and that you are committing to train lawyers about the use of these law reports and mobilizing them for using them. This is a very important commitment that I think is going also to boost the effectiveness and the professionalism among lawyers. Now let's see the use of these reports among the academia and the research world. And I would like to ask Dr. Aimé Muyoboke, the director of the ILPD, on behalf of other schools here present and not even present, but who have law schools. How do you, how does these reports serve the academic and the research world? How do you find this the special reporting, actually, not this one also only, but how do you find this initiative of having some special reports? You have heard the president of the MIC mentioning that there is another publication which is called Digest, containing also specialized areas. How do you find them? Do you find they are helpful for the academic and research? Or do you see any improvement on that needs to be done on those three ways of reporting? Please.
Thank you, Justice Isabel. Thank you, Honorable Chief Justice, for the invitation. And I would like to start by an apology due to my voice. I had a cold a couple of days back. And I greet all the leaders in the room and your respective positions or protocols observed. So the Institute is very pleased to be here and to be taking part in this conversation. We all know that there is no one single country, so far as I know, which has been victim of a genocide that was prepared. Many of the countries that were subjected to genocide, they were almost caught without proper mechanism, including legislations or precedents. And so, building from what Professor Ngagi was saying, everything that is related to genocide, not only in Rwanda, is a precedent. because the president is identified by 4 standards: the fact of establishing a new rule, the fact of modifying an existing principle, the fact of clarifying a question that was doubtful in legislation, such as the principle for joint criminal enterprise that was discussed by Justice Didas, or simply because the judgment was so instructive that it has to be reported. So, and we find that now, since 1948, when the Genocide Convention was adopted by the UN, it was not enforced. It was not domestically enforced until 1990s. And every student who is engaged in international criminal law would learn 2 cases. So far as I can recall, we have 2 cases. The first one is the case of Adolf Eichmann, which was delivered by the Supreme Court of Jerusalem. He was charged and convicted of the crimes against the Jewish people. They just avoided to call it genocide, but it was genocide indeed. The second case is the case of Augusto Pinochet, which was reported by the House of Lords in the UK. But why do students or researchers, even the judges, refer to these 2 cases? It is simply because they were reported. So it is not because they are smarter than the other cases, because they were available. For instance, the Eichmann case, being the first case to make a domestic interpretation of the Genocide Convention, was reported by the International Court of Justice in the international report. And so it was reported in French and in English and probably in Hebrew. And so it became accessible to everyone. And now all the researchers, all the academicians, all the universities, they started writing on Adolf Eichmann. And Adolf Eichmann has become a popular case because it was reported. So the Augusto Pinochet, it is also the same. But the 2 cases, Augusto Pinochet and Adolf Eichmann, we cannot compare them with the situation in Rwanda. Rwanda has a unique situation in the world. It is the only country in the world which has made a commitment for full accountability for international crime. Many other countries, we consider South Africa, Sierra Leone, even Chile, Germany or Europe in general, none of these countries have ever made a full commitment for international crimes. Only Rwanda has made a full commitment for accountability for international crimes. Rwanda is the only country which has been victim of a genocide, which has been able to make domestic interpretation of a genocide convention. And it has done it sometimes against all the odds, because we even introduced the Gacaca codes. So now, as we were a victim of these atrocities, now we have something we can offer to the world through reporting. So it is not only for the interest of our trials domestically. It is also building a full knowledge and skills, a full regime around the Genocide Convention. So I would start from there, indicating that reporting is crucial, is very important for the development of the law. It's very, very, very important. This morning, I read an article which was published today in India by a Rwandan on a criminal in criminal matters. And I'm going to indicate that was what I read in the introduction of this paper. The junior Rwandan researcher states, and I'm quoting, he was referring to the cases in Rwanda. He says, practical cases in Rwanda reveal that defendants are often convicted without a thorough analysis of mens rea, despite it being a fundamental prerequisite in criminal proceedings. So the researcher was, in fact, comparing the situation of Rwanda with the Moncton Rule, which is a popular rule in UK related to insanity. But when I was reading his paper, he referred to an Moncton case law in the UK, he referred to Canada, and he quoted only one single case from the Court of Appeal. Only one single case from the Court of Appeal. And the article is already published in an international journal in India, and artificial intelligence will take it as if it is true, and many other researchers will rely on it. And this is because, indeed, we don't necessarily have available data. The data are not necessarily reported. So if we had reports available, that's one, but also they should be accessible, because availability and accessibility are different concepts. They should be also accessible, so that they can inform the academic world, because also the judges, the work they do, the judges, they do academic work. So because all the time the judges are writing their judgments, especially the judges from the Supreme Court and the Court of Appeal, they make a research. So it is important to have these law reports accessible and available, so that we can have accurate data, accurate information. I would like to record a discussion I had in 2023 with someone at the time of revising the Constitution. There was a question of knowing whether we should include in Article 95 of the Constitution a paragraph related to the president coming from the Supreme Court or the Court of Appeal, so that they can have a value, a binding value, and so that it can strengthen Article 152, paragraph D of the Constitution, relating to the value for president in our legal system. So, anyway, I think we were not prepared by then. I think Prof. Ngagi said it very well. Having the civil law tradition, it was very difficult to introduce a new paragraph in Article 95 of our Constitution. But what we see today, the way the Supreme Court is handling cases, the way the Court of Appeal is handling cases, what we're witnessing today is that the courts are filling the gaps of policymakers. We have seen, for example, in the case of Murangwa, the Supreme Court giving opinions about taxation. We have seen in the case of Kabasinga, Florida, too, the Supreme Court giving position about how judicial independence should be understood, how sentencing should be understood. So the judges are no longer the mouthpiece which they used to be in the past. They are supplementing gaps. They are helping the lawmaker. They are helping the government, to frame policies and to fill the gaps which are there. So it is important that when the judges are doing this job, which they are doing, they are discharging this job in the interest of the people. That is their mandate also under Article 152, paragraph 1 of the Constitution. So the people should know. So there should be a mechanism. The same way the Parliament does it in official gazette, the same way the judges should make it public for the sake of transparency, but also for our own interest in the research, so that people can know their rights and then their obligations coming from these cases. So, in my view, the more we publish the law report, the more we are creating this new legal system that Professor Ngagi was mentioning, which personally I don't call it a hybrid, because hybrid would mean breeding two systems. But we have also included some elements of our customary law. So we have more than two systems, and we are creating our own legal system. And it is important that as we are moving towards this a new product, that we create institutions, a mechanism, legislations, procedures, capacities around it. Thank you very much.
Thank you very much, Rector Dr. Muyoke. Thank you for mentioning that this report is going to enter into the international framework of case laws and documentation, as opposed to what we used to have. You mentioned that given the nature of the genocide against the Tutsi, every case of the genocide, about the genocide against the Tutsi, is a case law internationally, because there has been none like the one you had here in Rwanda, and it produced now very key information for academics, and you've mentioned that, and we are happy to know that we should be proud that in addition to the Itman and Pinochet cases, probably we are going to see references to cases of genocide against the Tutsi from this raw report. I think you had also mentioned one recommendation about, you said should the raw reports, the case, the precedents be added in the law hierarchy. Probably this is a question that one needs to discuss more and see whether it should be mentioned in the Constitution among a source of law that is to be considered. Thank you very much. And thank you, panelists, for your contribution. I don't know whether one has one last comment or recommendation. If you have one, I should give you 1 minute. Yeah, Didas, do you have any? In a very few minutes. Only 1 minute. If you can use less, please do. Microphone is not on.
Okay, thank you, Chair. Hope that there is no specific recommendation on my side, but what I want to say is to encourage everyone to read this special report. Even if, we summarized some of them. It contains several rules that can help in researching, in writing cases, if prosecution, even in investigation. Thank you very much.
Yeah, thank you. Mine is just, I want to say that there is no single jurisdiction in the world that has adjudicated genocide cases more than Rwanda. So the special law report has come timely, and as the lecturer said, we need to have these law reform law reports published, and because we need them to be accessible wherever, everywhere, so that they can know what is happening, especially to these extradited cases. Let's have them accessible. Thank you.
All right, thank you very much. Mine is again to thank you. We've been working with the Court of Appeal to make sure that we train as much lawyers as we can, but as I did commit in my earlier intervention, we are going to be again coming to you, Your Lordship, President of the Court of Appeal, so that we can make necessary improvement. And part of our AGM that is coming up in December, we send a message about this law report, but also share it on their respective emails so that it can be used going forward. Thank you.
Thank you. So now I think we have embarked on a very big journey, Honorable Chief Justice. So we will probably be having all Rwanda law report, which is a general report which can contain different cases. Now we have, I think, two specialized reports, the constitutional cases and the genocide cases. But I think it is important also that we start planning about new areas, such as a commercial law report, which would be very helpful for Rwanda Development Board and the Ministry of Commerce, but also the business industry in general. We can also think about gender-based violence cases, as well as family and succession cases to start with. But also, in addition to this, in addition to the Rwanda Law Digest, which is in the pipeline, it is important we start thinking also about the case commentaries and the case annotation, so that this can help even in deciding future cases. So these are my further take, but these of course will go together with strengthening the unity of law reporting. There is an area in criminal law, because I can see a fund here which needs some specific attention, even on the website, the military criminal cases, which I think we don't have many of them reported yet. Thank you.
Thank you very much, panelists. Thank you for your attention. Thank you for your time. I would like to thank also the organizers who gave me the opportunity to chair this panel. And as a take home, I think this special report is going to be a key tool in our Rwandan justice system, especially if, in pursuing and prosecuting cases of genocide from other countries. I would like to take this opportunity, though I'm not delegated to do so, to thank the European Union, because some of the cases come from the European Union countries, and we hope that this report is going to help them, motivate them to bring effect. Thank you very much. Have a nice day.
Thank you so very much, Lady Justice and the entire panel. Please help me put once again your hands together and give them a hand. They've done justice to the topic, and definitely I hope all of us that are in here in the house and those that are following us online have really learned one or two things, and that they echoed. They've told the story that is ought to be said. As Maya Angelou says, the worst agony is the untold story. So the journey has started that we speak our story so that no one else will speak our story. So thank you so very much. And your lordships, we are transitioning to the mountaintop of our event. And at this juncture, it's my singular pleasure and honor to welcome Her Excellency to deliver your remarks. Thank you so very much. Please give a clap as she comes. Thank you so very much.
So, Honorable Chief Justice and the Deputy Chief Justice, the President of the Court of Appeal and the Deputy President, the President and Deputy President of the High Court, the President of the Military High Court, the Secretary General of RIB, who was here, my sister, the Chief Prosecutor, the Chairman of the Bar Association, but all protocols observed, the whole Justice and Reconciliation family in Rwanda here present. It really is a great honor and a privilege to be here together this morning for the launch of this Rwandan Law Report and the special volume that has been dedicated to the cases on the genocide against the Tutsi. This is a testament of the commitment of the government and of the judiciary to the access to justice, to accountability, and to the fight against impunity. And it's a great pleasure and a privilege for the European Union to partner this process and this exercise of the past 4 years. It really is one of these beautiful moments where, as a partner, we can see the impact of the work we're doing. And this really reflects on our commitment and our collaborative effort on the justice and reconciliation effort. So the European Union has been a partner of Rwanda since the end of the genocide against the Tutsi. The Chief Justice was reminding me this morning of the work that we did together in the Gatsata tribunals. But since then, we've been contributing also to the policies on the criminal justice system and also on the alternative dispute mechanism and on this very important compendium of legislation, of jurisprudence on cases on the genocide against the Tutsi. So it's a particular effort to strengthening the justice delivery, to promoting reconciliation and reintegration, to amplifying the citizen voice, and that's part of a justice and accountability program that we are together implementing with the Chief Justice, with the Ministry of Justice, with the National Prosecution Authority, with RIB, with the Correctional Services, with Human Rights Commission, and with the civil society here present today. I have to say that it really is a delight to hear the panel that we just witnessed together. This special volume, it really represents, I mean, it documents on the landmark jurisprudence on the genocide-related cases, and in doing so, it strengthens the consistency, the transparency, the efficiency, and also the access to justice in Rwanda. But beyond that, it serves as a reference, as we heard, for judges, for the prosecution authority, for lawyers, for academics, for citizens. And I had the opportunity to open the pages of the compendium, and it really is a deep dive into history. And it will provide a living document for education also on the reconciliation journey. It also is a reference and a precedence, not only for the courts on Rwanda, but also for the international courts, and it certainly contributes to the compendium on genocide across the world. And this is a very significant contribution, and I want to congratulate the judiciary for this effort and for this journey and for the result that we now see on our tables. So with this, I think I would like to encourage all the stakeholders to now collaborate in disseminating these reports widely. We want to make this a living tool for the courts, but also for education, reconciliation, and accountability, and to fulfilling the work that we are doing together in the Justice and Accountability Program, but also in the Justice, Law and Order Sector Strategic Plan in Rwanda. So we are together building a legacy of justice, accountability, and unity. And as the Chief Justice told me earlier this morning, this is a work that we're leaving for the next generations. So thank you very much. I would like to reiterate the European Union commitment in this journey. We will continue working together. And thank you very much, Murakoze Tsane.
Thank you so much, Honorable Excellency Ambassador, for your kind remarks. And again, thank you so very much for the input and making this happen. Your Lordships, ladies and gentlemen, we are transitioned to the last item, and which is the most important item, where we'll be having the actual launch, but also the remarks from the guests of honor. So it's my humble honor and privilege to invite the Honorable the Chief Justice to please come and address us and consequently launch the compendium. Thank you.
Your Excellency Belen Calvo Uyara, Ambassador of the European Union to Rwanda, esteemed representatives of justice sector institutions, distinguished members of the civil society and justice sector stakeholders, respected members from the academia, invited guests, ladies and gentlemen. It is my great honor and privilege to welcome you all to this event, the launch of the special law report dedicated to genocide cases. This work marks a significant milestone in the strengthening of our legal system and in the consolidation of Rwanda's commitment to the rule of law, transparency, and access to justice. The 1994 genocide against the Tutsi claimed more than 1 million innocent lives, tore apart the fabric of our society, and left wounds that may never fully heal. Yet, from those ashes, Rwanda chose the path of justice and reconciliation. The judiciary has carved out a sacred responsibility of holding perpetrators accountable, guaranteeing the rights of survivors, and contributing to building a society founded on the rule of law. This special report is a testament of that responsibility. By compiling landmark rulings on genocide cases, we are not only preserving legal precedents, but also safeguarding the truth against distortion, denial, revisionism of the 94 genocide against the Tutsi. The Raw Report is not only a tool for legal practitioners, scholars, and students, it is also a testimony of our judiciary's commitment to ensure that justice is administered consistently, fairly, and in full respect of our Constitution and laws. Reliable law reporting is the backbone of any credible legal system. It provides guidance, fosters predictability, and builds public trust in judicial decisions. Today, as we launch this special law report on genocide cases, we reaffirm our collective determination to ensure that justice, memory, and truth prevail in the face of one of the darkest chapters in our nation's history. Your Excellency, Ambassador of the European Union to Rwanda, ladies and gentlemen, this special report and the regular reports are on display, available on the website of the Judiciary, www.judiciary.gov.rw, are not an end in themselves. They are tools to serve justice. Their true value lies in how they are used to advance fairness, equality, and protection of rights. I therefore call upon all legal practitioners to embrace these reports, to apply cases laws set with diligence, and contribute to their continuous improvement. I wish to commend the Multi-Institutional Committee of Law Reporting, the Inspection of Courts, the Law Report team, and all partners, especially the European Union, for their valuable contribution towards this law report on genocide cases. Your work has assured that Rwanda jurisprudence on genocide is preserved, studied, and applied in our country and globally. On behalf of the Judiciary of Rwanda, I officially launch this special law report on genocide cases. I thank you for your kind attention.
Thank you so very much, The Honorable the Chief Justice, Excellency, ladies and gentlemen, we've come to the conclusion of this event here. As I said, we have a group photo that will be taken outside, but we also have the stands that we have all these copies that will be issued to our guests. So the protocol will usher out our guests. And lastly, we have a luncheon to celebrate the launch. So please, guests, don't leave us. We want to have with you a lunch and then depart. So thank you so very much. Thank you for being a very good audience. And once again, another round of applause. Thank you. Have a good day.